The the training suite is, let's say, structured in 12 12 modules, which are expert-led and at 3 levels: first, basic, intermediate, and advanced. Just one explanation why this deep dive. In our first deliverable, we analyze needs, and we find out that our audience are practically people who are not very knowledgeable and not aware of standardization, but they are very interested in IP area. So we thought that this topic would be great for deep dive. To do so, today we have practically the best of the best. So today we have our guests, our distinguished guests, who will help us to get more about this topic. First, let me to introduce to you Judith Fearens. She works as a legal counsel at CEN, European Committee for Standardization, and CENELEC, European Committee for Electrotechnical Standardization, advising on contracts, intellectual property, data protection, and legal aspect of European and international standardization. Before joining CEN and CENELEC, she gained experience in legal consultancy and the telecom sector, specializing in data protection and contractual matters. Our next presenter is Magali Fitzgibbon. Magali is Legal and Governance Director at ETSI, European Telecommunication Standards Institute, where she oversees legal strategy and governance. Previously, Magali served in various positions, including as IP legal expert at IAM4RE Institute, National Institute for Research, Information and Automatization, where she had opportunity to work on intellectual property issues related to software and technology transfer. Magali is passionate about intersection of technology, law, governance, and regularly contributes to discussion on future of intellectual property and innovation in a global context. Our third presenter is Belinda Cleland. She is a policy specialist with over 15 years of experience working at the intersection of international standards, innovation policy, and global governance. She previously served as head of research and innovation at the International Organization for Standardization, ISO, where she led research on economics and social impacts of standards and explored how standardization can support innovation and technology diffusion. Today, I have a great honor to greet our distinguished presenter. And first, I would love to ask Judith to start her presentation. Judith, the floor is yours.
Thank you, Ivana. Thank you for having me and organizing this webinar. I think all my screen is now visible, so then I will start. So good afternoon, everybody. Thank you for joining this webinar. So today I will try to give you a high-level overview of CEN and CENELEC policies on copyright and patents. Before we will dive into that, first, just an explanation of who CEN and CENELEC are. So CEN and CENELEC, together with ETSI, are officially recognized as European Standards Organization under Regulation 1025. Whereby we focus on various domains on standardization. So CENELEC really focus on electrotechnology, going from standards from electric cables to fiber optics to medical electrical equipment. Whereby CEN focuses on various business sectors, going from fireworks to...
Sorry, Judith, we can't see your slides. Sorry.
Ah.
Yeah.
What do you see?
We just see you. Which is very nice. There you go.
Yeah.
There you go.
Sorry.
Okay, they're coming up now. Okay.
You see them now? Apologies.
Yeah, we see them now.
Okay, that's great. So yes, as I was saying, so we have various domains of standards that we apply, and I think my counterpart on this webinar shall explain a bit more on ETSI itself. So now, it's apologies. What is no? I have an issue with my slides. I cannot.
I can share them if you want, Judith.
Yeah, it's maybe
Okay.
easier.
Just give me a second. Hey. Can you see them?
Yeah, but they're not in presenter modes.
No, so. One second. Okay.
Yes, thank you very much. Sorry.
It's all right. No.
Okay, I think you can go to the next slide. Okay, so CEN-CENELEC is a membership-based organization aligned with World Trade Organization principles, whereby we adhere to ensure transparency, openness, and inclusiveness, meaning that we have specific mechanisms and procedures in place to not only involve European stakeholders, but also on a national level, involve small and medium enterprises, societal stakeholders in the standardization development process to ensure that we have all the relevant expertise that is available. So the standards are developed to support the market and EU legislation, meaning that if you adhere to a standard for certain products and services, you know that you can sell them across 34 countries and reach almost 600 million customers. So that's quite a nice benefit of using standards. And also at CEN-CENELEC, we have a systematic review of standards to ensure that they are up to date and have maintained state of the art. To ensure that we can provide the best standard that there is. You can go to the next slide, please. So this slide is just to show you where CEN-CENELEC is located. So as you can see, we are at the European level together with ETSI. We work closely together with ISO and IEC, with whom we have cooperation agreements in place. And as I mentioned before, we have also our national members that ensure that standards are nationally implemented across the different countries. So this is just a nice overview of the standardization system that we have in place at the moment. Next slide. And then to focus on why we are here today, to discuss intellectual property rights in the standardization context. So today I will discuss two main types. So we have IPR in the standard itself, then we will discuss patents. And if you just do one more click, then you have IPR of standards, and then we will discuss copyright. So what are patents? If you go to the next slide, I just provided a very generic overview for the people who are not aware that it's exclusive rights that are granted for an invention for a period of 20 years. There are certain conditions that you need to follow to get a patent. So it needs to be new, meaning or novel. It needs to be not made publicly aware before. It has to have an inventive step, meaning that for somebody who is an expert in the field, the solution should not be too obvious, and it should also be susceptible for industrial application, meaning that it can be used within a certain industry or within a certain trade. So within CEN and CENELEC, we have a specific guide developed, namely Guide 8 on the patents, whereby a patent is defined as a temporary limited legal right granted to an inventor to prevent others from manufacturing, selling, or otherwise using rights based upon her or his invention, just to ensure that a patent confers that monopoly that excludes others from using a certain invention or tool, product, process. If you go to the next slide, we will dive a little deeper in about our patent policy itself. So it really defines how innovators inform others or to protect an invention. And really the goal of Guide 8 is to guarantee that there's an effective access to standards and the use of them. So Guide 8 is based upon three pillars, namely the first one is early disclosure, whereby there's an important role of experts, of the chair and secretaries of technical committees and working groups, so the people who are really in the standardization development field, that as the moment that they become aware of an essential patent, that they need to inform the technical committee to ensure that we can take the necessary steps. In Guide 8, there's also a balanced approach whereby we have to take into account different rights that are at stake. So of course, we have the right of the patent owner that they cannot be infringed. So we have to ensure that that's well protected. We have the right of third parties that wants to use and sell products. So they want to make use of that standards, and they need to be protected in the possibility of using that one. And we also have the public interest to protect against abuse of intellectual property. For example, we have a patent ambush whereby there can be an expert or a company that's taking part of the standard development procedure, whereby they would intentionally hide that they have an essential patent that can be used within the standard. And then once the standard is approved and implemented, then they will disclose that information, and then they will ask for a high license fee. So this is really to ensure that all the rights and obligations are well defined in Guide 8. And then at the last point, we have transparency. So on our CEN-CENELEC website, you may find a declaration database whereby we have an overview of all the declaration forms and the applicable essential patents and the standards that are related to it. So I think it's also a very useful document to take a look, which you can do via the link. If you go to the next slide, so which kind of patents are included? So it's really patents that are essential for the standard, meaning that when you want to use a product or use a method, you cannot, according to the standard, you cannot do so without infringing the patent holder's rights. And the patents of which we have license conditions are declared. So in Guide 8, you can find at the last pages, you can find a declaration form that can be filled in by the patent holder. This declaration form is based upon fair, reasonable, and non-discriminatory conditions, meaning that fair and reasonable, that the license fee cannot be too high, it has to be well balanced, and non-discriminatory, that there's need to be a fair treatment of across the same similar license situations. So if you go to the next slide, you will see, so we have our standard essential patent declaration, and there you have 3 different options. So option 1 means that the patent holder is willing to negotiate, but this will be free of charge. So there will be no monetary compensation, and it will be based upon non-discriminatory terms. The fact that there is no monetary compensation does not mean that there cannot be any other conditions that they want to be followed, like register in a certain database or providing a certain name. Then option 2 is that the patent holder is willing to negotiate based upon a non-discriminatory, but also well on a fee. So there will be some monetary compensation. So if you go for option 1 or option 2, this states that the patent holder is willing to negotiate, and those negotiations will fall outside the scope of CEN-CENELEC. So we will not be part of the discussion between the patent holder and the person who is willing to use the patent. Also important to know is that these declarations are irrevocable to the extent that the patent remains essential to the standards. There's also a possibility of reciprocity, meaning that if you are willing to license, it can be on the condition that the other persons who want to license your patent is willing to also license their patents, a bit like a quid pro quo situation. And the declarations will also bind all successors, meaning that if I'm a patent holder and I will transfer that right to a third party, they will also be bound by the conditions of my declaration form. What will we do if option 3 will arise? So meaning that the patent holder is not willing to grant a license. So therefore, we need certain information. So we will need to have the granted patent number and the patent application number. We will need to know or have an indication of which kind of portions of the standards would be affected. And also, therefore, it's the importance of the early disclosure to have as soon as possible any awareness of these patents that exist to avoid that we have to later on remove elements of those patents. If you go to the next slide, there's just a very easy practical implication whereby if there would be a company, a solar company, for example, that makes a product and needs to implement a standard, in that standard, there's a reference to patent technology of company B. So that's company A needs to license that patent technology. So if company B has filled in the declaration form, it's clear to company A that they are committed to deliver such a license for free or for any payments. So this way, the standard can be implemented and there's like an effective use of the standard itself, which is the main goal of our Guide 8. I think with that said, I think we can go to the next slides. So besides patents, I also disclosed that there's IPR of standards itself, so the copyrights. So what is copyright? It protects the work that's an original intellectual creation. This should be expressed in a concrete form, meaning an ID is not sufficient. If you just do one more click, there are some examples at place. So this protection comes automatically when a work is created. There's a broad range of works. Think of books, images, photographs, software as well. But important to know is that copyright works cannot be used or reproduced without prior permission. This is really the main goal of the whole copyright protection. If you go to the next slide, you will also see that besides the Guide 8, we have also a Guide 10 on distribution and sales of CEN-CENELEC content. So the whole purpose of this guide is to explain why standards and other content are protected by copyrights and how our standards are distributed and sold. Because a difference with other standardization organization is that CEN-CENELEC does not sell itself in a centralized manner the standards, but this is done by all of our members who have the rights to sell, distribute, translate within their own territory. So this is a difference that you need to be aware of, that it's not CEN-CENELEC who will do it by themselves. If you go to the next slides, so of course the standards are copyright protected work. They do meet the threshold of originality because they're to reflect creative and free choices. So as I mentioned before, if you want to use a standard, you need to have the prior permission of the copyright owner before you can do anything with it. If you would reference or if you would reproduce copyright content, it's very essential to cite and reference. Also, an important thing to note is that sometimes standards will be referenced in law and in regulation. This does not mean that it's because it's in the law that there is no copyright protection, because it has been established that certain standards do form part of an EU law and therefore they need to be publicly accessible. But the fact that they are publicly accessible does not mean that the copyright is no longer there. As I mentioned before, our members do rely on this of the sales of standards. So this is a very important part of their business models. And therefore, copyright is essential to uptick and to ensure that that's an important thing to protect as well. If you go to the next slide, we can see how you can just, I think, click how it works. So how does it work internally? So when you have experts or third parties that form part of a technical committee of a working group, they will sign via an exploitation right assignment statement of license agreement. The wording is different, but the intention behind the document is the same, whereby they will sign away their rights, exploitation right and copyright to CEN-CENELEC to allow to creation of a collaborative work. So we have the standards. The fact that they would sign away certain inputs of themselves does not mean that they can no longer use their own inputs, but it cannot have an adverse effect on CEN-CENELEC. We had an example in the past whereby there were some experts that wanted to publish their inputs in a magazine or in like a journal, but this was not allowed because the standard was not yet made available to the whole public. So this would have an adverse effect on CEN-CENELEC. So if you have then the CEN-CENELEC content, there we give the rights to our CEN-CENELEC members to allow them to have a broad exploitation rights within their territory. If you go to the next slide, it's a bit easier maybe to understand. So as I mentioned, experts, third parties who take part in standardization development process will assign their copyright and exploitation rights to CEN-CENELEC. Then CEN-CENELEC on their turn will assign it to their members to allow them to use it and to sell standards in their territory, while CEN-CENELEC will remain a copyright owner. I think if you go to the next slide, this is just a short reminder that indeed CEN-CENELEC has the copyright. We do not sell it in a centralized manner, but this is done really via our members. And the fact that all the rights and inputs of the experts are signed away via certain assignment statements. And in the case that that's not done yet, we need to have an agreement in place to ensure that it's covered and all these documents are saved in internal tools. So I think when we go to the next slide, I just wanted to show the link to this Guide 8 and Guide 10 that I discussed, because I think this is very important information to review and to take into account for some light reading. And I think on my side, that's a bit, it's what I wanted to say in a short nutshell. So I think I will give the floor to Magali. Yes.
Thank you so much, Judith. Magali, the floor is yours.
Okay, I'll just share my screen. So can you see my screen?
Yes.
Okay, great. So good afternoon, everyone, and thank you very much for this invitation. And especially as I worked before in a technology transfer, it's nice to make this presentation in this context. So I'm going to give you what I would call an introduction to the ETSI IPR policy. And as you're going to see, there are quite some similarities with what Judith presented to you. And also because very often SDOs tend to yes, have quite on some topics similar practices. So we'll come back on this. So just for a short presentation of ETSI, very short presentation. So we are a not-for-profit organization. We are a French association, so organized under French law. And we have direct membership, so meaning we have over 900 members across the world. So it's in more than 60 countries and in diverse sectors of industry and society. So among our memberships, we have big companies, we have SMEs, we have universities, research institutes, national standard organization, administrations, branches of government. So it's a very wide and not only stakeholders in telecom sector, because when you talk about ICT today, you find it in many different industry now. So, for example, we have also members from the automotive sector, for example. So it's a very wide membership. So as a standard development organization, we have a focus on ICT and digital standardization. So I give you here a few examples of broad, big domains that we covered. And if at the beginning, ETSI was very focused on what was telecommunication, now that, again, telecommunication is something that expanded in many of adjacent domains in industry. We in the last years, our scope also has extended to some adjacent domain to ICT, such as cybersecurity, AI, and now quantum data. And so, like CEN and CENELEC, we are an ESO, a European standard organization, and we have therefore the possibility to develop standards that are going to come in support of European legislation. And we are also involved in a big partnership project, which is the third generation partnership project, 3GPP, which at the beginning developed the standards for the 3G, then 4G, 5G, and now work started on the 6G. So that was for a very short presentation. And now if we move to standardization work and intellectual property. So like Judith, we are going to see a few things about copyright. When you talk about standards, we're going to have topics about patents. Although I'm not going to develop this topic today, there also are antitrust issues in relation with standardization, and in particular with intellectual property, because it was mentioning the fact that you can have patents related to standards, and patent being a monopoly, and the standards being used on having a big impact on the market. That's also why we have those IPR policies in a standard development organization, it's also to mitigate antitrust issues. So I'm going to start with copyright in a nutshell and very quickly, because I would like to focus a bit more about patents. So at ETSI, we, like CEN-CENELEC, we own copyrights on the standards that are developed by our members. We rely on the notion of collective work. So ETSI is the organization responsible of developing this work, editing it, publishing it, distributing it, and so we are the owner of the copyright of the standards that are produced. However, our members keep ownership of copyrights on the individual contributions. So meaning when they submit us a technical contribution, whether we include it or not in the standards, they keep the possibility to use that contribution somewhere else or on their own. So we make the distinction between the copyrights on the standard itself and the copyright at the level of our members' contributions. Our standards can be downloaded for free on our website. So we are not selling the standards. So that's where our business model is a bit different from other standard development organization. Our business model, in fact, is based on the membership fees that we collect from our members, and not based on the sale of our standards. And however, nevertheless, even if we are available for free on our website, we'll still have some agreements with licensors that wish to distribute ETSI standards. And usually that will be either some governmental agencies or national standard organizations that want to adopt some of our standards at a national level. So if I go now to patents. So here we're going to juggle with two concepts. So this concept of standards. So I put you here a little definitions, but I think that you probably previously had a module actually explaining what was a standard. And having in mind that in the domain of ETSI, ICT standards are essential to facilitate interoperability between products in what is today a multi-vendor, multi-network, and multi-service environment. And the other key notion for this is going to be the patent. So here the definition that is provided by WIPO. And if you look at ICT standards, they rely on technical contributions from various sources because they provide from our various members. And therefore, that means that those technical contributions coming from various sources can also possibly contain patented technologies. And that's when we're going to have a standards meeting with patents, and we're going to have this notion of standard essential patent. So meaning a patent protecting a technology that is going to be essential to a standard. So we also have, like CEN-CENELEC, a definition of what we call essential in our IPR policy. And just to summarize, like for CEN-CENELEC, it will mean that if you cannot use the standard without infringing the patent, then this patent will be considered as essential to the standard. And that's where we have to deal with a little contradiction, because on the one hand, we have a standard which must be available for all implementers on the market, so to the greatest numbers. And we have essential patents that may exist for given standards, and therefore with a monopoly, and therefore the possibility for the patent owner to block the access to this patent, and potentially, therefore, to block the access of implementers to the standards, and therefore have quite a control on the corresponding market. So that means that we need to find a compromise between the fact that we need to have the standards available for implementers, And we need to also preserve and consider the right of the patent owners. And that's what is the purpose of a ETSI IPR policy, is to provide a framework to provide such a compromise. So indeed, this IPR policy, so it's going to facilitate the standard making process within ETSI. And we are going to try to provide a fair balance between our members' rights on their patents. And ETSI's objective is to create standards and technical specification based on solution which best meet the technical objective of ETSI. The goal is not to avoid patented technology, but on the contrary, if we want to have standards that are in the state of the art with cutting-edge technologies, so if it means that some of these technologies are patented, we have to find a way to include those patented technology into the standards. So that means that the ETSI IPR policy is going to define rights and obligations for ETSI as an institute and for its members to achieve this balance. So we are going to rely on the importance to have knowledge in a timely fashion of the existence of patents that could be essential to standards. This policy will enable to reduce the risk of having a patent that will not be available to all implementers when included in a standard or technical specification. And it is also going to provide an incentive for members to encourage them to contribute the patented technology by giving them the perspective of a return on the investment. So this is important. You have you also have SDOs that have different policies that are based on for patents on royalty-free regimes. It is not the case of ETSI, mainly because we're in a domain where we know that depending on the standards, there can be a lot of investment in research and development for members, a lot of investment in the development of a patent portfolio, and we have to consider this in the IPR policy, and that's where this perspective of return on investment is important. So what is this policy is going to ask is first, like in CEN-CENELEC, we are going to ask our members to disclose the patents that they believe to be essential to a standard. So I give you the corresponding article in our policy if you want to have a look at it after this webinar. So there's an obligation to disclose in what we call a timely fashion. We do not impose a very specific calendar or deadline to do it. We encourage our members to do it as early as possible. And also what is important is when our members make such disclosure, ETSI does not check the essentiality of a patent. We consider that it's for a member to make this assessment and to determine whether they believe the patent to be essential or not. We are not going to double check it when we receive the disclosure. And then we are going to ask our members if they are willing to make a friend licensing commitment. So meaning to give, if they are willing to give a license to implementers that will need to have access to this patent on the basis of fair, reasonable, and non-discriminatory conditions. So this is a commitment, like Judith was saying, that is meant to ensure that the standards will be available to all implementers, even as a patent essential to it. But it's also going to be an incentive for the patent holder, as I was saying, to contribute patented technology in the standard. So this friend licensing commitment is also going to be binding for all successors and interests. So meaning if the SEP holder sell the patent to another organization, this other organization will also be bound by this friend licensing commitment. It's not possible to leave it aside. Also an important thing, ETSI does not define what is a friend rate. That is part of commercial discussion between the patent holder and the implementer. And ETSI does not take part into licensing discussions. That is also to be left between the patent holder and the implementer. So how it happened in practice is every time we have a meeting in a technical committee, the chair of this technical committee is going to make a call for IPR. So meaning that the chair is going to remind all participants that if they have patents that they believe to be essential, they have to declare them. And if I remember a bit of my experience in public research, what I noticed when I was working in public research is when researchers go and attend such technical committee and hear that type of calls, very often they tended to think, do I have patents that could be essential that we filed within my research team? And what is important is to remember that it's in this case, it's not only a question of do you have essential patents in your research team, but in the whole organization to which you belong, whole patent portfolio of the organization. Then, if one of our members believed that they had an essential patents, they have to disclose it in our database. So we have a database which is online and with a process that is a fully online process in which our members can disclose the patent and in which they can also indicate if they are ready to make or not a friend licensing commitment on this patent. And so this database is publicly accessible. So any implementers then that wishes to go and check if a patent, one or several patents have been declared for standard, they can do so online. And what is also important is in the ICT context, very often when you have disclosure of such patents, it's not a declaration of one single patent. Very often it's in the telecom, traditionally in the telecom industry on those topics, you are more in the logic of having a patent portfolio, big patent portfolio that you develop in relation with some technologies. And so that means that very often when our members make such disclosure, it's rarely, not very often, it's not for one single patent, but for a much bigger portfolio. And so that's also why our process is online. It's also a way to make it easier to proceed with those disclosure. And should a patent not be available, then we have a procedure in which our Director General has to contact the owner of the patent to ask the owner of the patent to reconsider this position, ask eventually the reason of such an availability. And if an availability is confirmed, that means that the standards may need to be reviewed with an alternative technology to ensure that we don't need to use the patent that is not available. So that is in theory. In practice, it is, to the best of my knowledge, it is not a situation that we encountered at that stage, at least in ETSI. And usually our members do not have any issues with making the patents available under friend licensing commitment. So maybe to say a few words about the ETSI IPR database. So currently it is the biggest database for standard essential patents. So today, at the beginning of 2026, we have more than 500,000 standard essential patents that are disclosed in this database. A bit more than 6,000 since January 1st this year until the end of February. And so it's not because you have this notion of standard essential patterns that you have standard essential patterns disclosed for each ETSI standards. We have ETSI standards for which no patterns have been disclosed. That can happen. And on the contrary, we can have patterns for which we have a lot of disclosures for members. And that's the case, for example, with technologies that are related, and standards and technologies that are related to the 5G. And when in the context of a 3GPP work started on the 5G, that came with, we could clearly see it, it came with a peak in the number of disclosures in the ETSI IPR database. So disclosures, yes, it's depending on the standards and technological domain of the standards, it can be more or less, say, subject to patented technology. And also, our database has an interface with ESPASnet, which is the database at the European Patent Office in which you can actually find the patents that have been applied for. And that gives the possibility to declarants, when they declare patents in the ETSI IPR database, to import automatically, rather than doing it manually, all the patents that belong to the same patent family, whether they are filed in France, in the UK or Asia, whatever the country, as long as the data is available in ESPASnet. So when you have to deal with disclosure of big patent portfolio, this is actually a functionality that is very important and appreciated. And also we have some reporting tools that are available with the IPR database. Reporting tools for what I would call the simple users, if you want to have access to some figures and some trends. So it's something you can have access to. There's also an SQL queries that are available for most advanced users. And we also make available for free the data set of the ETSI IPR database, what I would call super users. So it's users that are going to use the whole data set, for example, in business intelligence tools in your organization. It is also used from some service providers that provide some services to analyze trends on patent, for example. And it's also used by WIPO in one of the tools, which is the patent scope, which is a tool which provides information on the patents they have in their own database. So it is something that is quite appreciated by quite many stakeholders. So just to say a few words on the ETSI friend licensing commitment. So because it's actually quite specific compared to other SDOs. So in the ETSI IPR policy, the friend licensing commitment is a promise of a license, which is considered in French law as a contract, which is legally binding. And it is quite different from quite many other SDOs IPR policies, which are usually going to refer to a commitment to enter in good faith into negotiations. And that I'm not going specifically to talk about a promise of a license as such. And in French law, so this friend licensing commitment has been recognized as what we call the stipulation pour autrui, and which is a concept which says that it gives a possibility for one of the parties to a contract, the stipulator, so here the stipulator would be ETSI, to require a promise from the other party, the promiser, so here the promiser is the patent holder, to accomplish an act of performance for the benefit of a third party, the beneficiary. The beneficiary here is the implementer. And this third party, so here the implementer must be a future person, can be a future person, but we have to be in capacity to be, it has to be identified, we must be available to determine at the time of the performance of a promise. So that makes this friend licensing commitment actually quite strong from a legal point of view and from a contractual point of view. And so to summarize in a nutshell, so the ETSI's IPR policy, so it provides a balance, a framework which is a balance between protection of patent technology with what is an open, interoperable standard to foster innovation and broad participation in standardization work. It provides also transparency, predictability for standardizations. That was also mentioned by Judith, and it's very important. It's very also important for the SEP licensing ecosystem and for the negotiation to come for those patents. And this is actually the foundation that is going to enable collaboration and efficient creation of widely adaptable standards, which also make this ETSI IPR database an important asset for the industry, because it's we're going to provide the basis and the foundations for then the licensing negotiation to come when the standard is going to be used in the industry. Thank you very much for your attention.
Thank you so much, Magali. It was very, very nice, and thank you so much for your input. Belinda, time is yours.
Thank you, Ivana. Can you see my slides okay? Yeah.
Yes.
Okay. Hello, everybody. Good afternoon. I'm here to talk to you about the IPR policies of the International Organization for Standardization. And luckily for you, we have a lot in common with what you've just heard from CEN-CENELEC and from ETSI. So there will be a bit of repetition in this presentation, but hopefully not too much. In the next few minutes, I'll walk you through three things. We'll start with what ISO is and how it works, and talk a bit about how standards are shared and sustained. So ISO's business model, which is slightly different from both CEN and ETSI. And then what happens with patented technology and our patent policy. So first, a bit about what is ISO as an organization. So this is a picture from ISO's first meeting in 1946 in London, which brought together 25 national standards bodies. And the organization has grown a lot since then. We are an independent, non-governmental organization based in Geneva, Switzerland. And through our members, of which we have 176, we bring together experts from all around the world to share knowledge and develop voluntary consensus-based international standards to support innovation and provide solutions to global challenges. An interesting fact about ISO is that ISO is not an acronym. We are the International Organization for Standardization, and the name ISO was actually chosen because it is similar in different languages. It's derived from the Greek isos, meaning equal. An important thing to note here is that we are a not-for-profit organization. However, we do sell our standards, and this is just to allow us to finance their development. And I'll talk a bit more about why and our business model a bit later. So we currently have 176 national standards bodies who are members of ISO. We have 250 more technical committees. Each technical committee has a specific scope, is developing standards in a different domain. And ISO actually develops standards across almost all sectors. So we have sister organizations, which are the International Electrotechnical Commission, the IEC, and the International Telecommunications Union, the ITU, which is a UN body. And IEC develops international standards for everything electrotechnical, ITU for everything telecommunications, and ISO for literally everything and anything else. So we have lots of different kinds of standards, and we have more than 26,000 of them. On average, we publish 100 new standards every month. There are three key parts of the ISO system. Firstly, we have the ISO Central Secretariat, which is based in Geneva and is coordinating the system. Then we have the ISO members, who are the national standards bodies of the countries, and there is one member per country. And then we have the experts, and we have more than 50,000 experts contributing across the system. What ISO-CS does is to coordinate and facilitate participation of all of these different countries and experts in the ISO system. We provide the neutral platform for the experts to come together to have all of their meetings and to draft the standards. So we are administering this very decentralized system. What the members do, the national standards bodies, is they represent ISO in their country, and they send their experts from the different sectors to the ISO technical committees to write the standards. And then when those standards are drafted, they bring together their national stakeholders to review and vote to approve or disapprove those international standards. They also propose new standards when their stakeholders come to them and tell them that they have a need to develop a new international standard. And the experts themselves don't represent their countries, but they come to ISO representing their technical expertise. They work together in working groups to draft the standards, and they are nominated by their national standards body. But we do also have experts that come from partners such as other international organizations, United Nations organizations, and so on. Now, ISO does have a strategy, the ISO Strategy 2030, and under that strategy, we have three main priorities. The first one is that ISO standards should be used everywhere. It's a big priority of the organization to facilitate access to standards. And secondly, that we want our standards to meet global needs so that we bring together the right international stakeholders to come up with a solution that works across borders and across markets. And thirdly, that all voices should be heard. So we make sure that we have participation from all of the concerned countries, including developing countries, and we offer specific support to get the developing countries to the table. So that was a brief introduction to who we are at ISO and what we're doing. And now I want to talk a bit about our copyright and access model and our business model. So ISO's business model is a bit different to CEN-CENELEC and ETSI in that we do actually sell ISO standards and our members sell ISO standards. So ISO standards are often described as being in the public interest, and they are, but they're not created automatically and they're not created in a cost-free manner. There is a huge cost to the system. Each standard may take several years and many meetings to develop. So there are years of global collaboration reflected in each standard, and this system requires coordination, governance, and continuous updating to review and make sure the standards stay up to date. So this is why ISO standards are protected by copyright, and they are provided to customers through license agreements. The copyright is not about restricting use. As I mentioned, ISO's big priority is to make sure that standards are used everywhere. But we really need to protect the integrity of the content and ensure that the system can continue to function by getting revenue through the licensing of the content. So to make this concrete, when you're accessing an ISO standard, you're not actually buying ownership of the content. You are really obtaining a license just to use it. And that license comes with specific terms and conditions. Typically, it's limited to a specific user scope. So you buy a license as a single user, or you buy a license to use it on a network with a specified number of users, or a license to use it so that everyone in your organization can use it. And these come at different price points. But the license is not freely transferable. You cannot reproduce the content. You cannot create derivative works from the content without permission. So the standard can be read, referenced, and implemented. And this is important because it's protecting the integrity of the standard content and the sustainability of the ISO system to ensure that the access to the standard is controlled and traceable and aligned with the licensing model. So I mentioned that ISO is a not-for-profit body, and it is not funded by public budgets. Some of our members are governments, but many of them are not. We are funded by membership fees and sales of standards, with roughly a 60-40 split. So 40% of our revenue that keeps the system going comes from the licensing of standards. So the pricing is really, for ISO, it's not about profit, it's about protecting our independence and ensuring that standards can be shaped by consensus and not by the influence of sponsors and donors or dominant actors that have the ability to pay. So in that sense, the pricing model is really linked to the trust and neutrality of ISO standards and the ISO system. A common question that we get all the time is, if standards are in the public interest, why can't we make them available for free? And the reality is that a fully free model would introduce very real risks to the ISO system. We would have fewer resources to develop the standards, to maintain the standards, to get developing countries to participate, and we would have too great a dependence on external funders. So ISO's approach to selling licenses is to try to balance access to standards with sustainability of the standardization system. So this means that we are trying to evolve, and we hear the pressures from stakeholders and from regulators who want to make standards referenced in regulation freely available and so on. So we are trying to become more open to this and evolve no-cost access in a targeted way, focusing on high impact areas that are policy relevant, such as sustainability, climate change, for example. So we do have a number of standards that are made available at no cost, but we do need to maintain a model that keeps our system independent and globally representative. So our goal is access, but also credible, trusted standards. So that was our business model and the importance of ISO copyright to maintaining it. And now I'll move on to talk a little bit about patents in standards. So like CEN and ETSI, we have this concept of standard essential patents. Standards are defining how technologies must work to be interoperable, and then patents are protecting specific technical solutions. But when a standard requires a patented method, that patent becomes essential. So it's a standard essential patent when you cannot implement the standard without that patent. And that is creating both risks and opportunities that the ISO patent policy is designed to manage. Oops. So what is this patent policy and what does it do? The aim of that patent policy is to ensure that patents don't block the use of standards. So if your patented technology is included in the standard, you must declare it and you must commit to licensing, most commonly under FRAND terms, similar to what the other presenters described. And ISO does stay out of these details. ISO is not checking whether patents are valid or whether the patent is essential. We are not setting pricing. We are not negotiating licenses. So the patent policy is creating access, but it's leaving the real IP management to the market and to the patent holder. So very similar, in fact, almost identical to the CEN model. When the patent holder commits to licensing, they either choose to give away free licenses, they choose to use the FRAND model, so fair, reasonable, non-discriminatory terms, or if they refuse to license it, then the technical committee has to find another solution, and that patent cannot be included as a solution within the standard. So how this works in practice is, as early as possible, during the development of the standards draft, the technical solution is proposed and the patent holder must declare that they have a standard essential patent, and they fill out a declaration form that is available on the ISO's website. It's common to ISO, IEC, and ITU. They choose one of the licensing options, free or FRAND. And if they're not willing to do that, then the technical committee has to find another solution. And similar to CEN, we do also have guidelines for implementation of this common patent policy, and you can download those from the ISO website. So one key point I should make is that buying a standard does not give you the right to use the patented technology inside it. So if implementation requires a patented method, you may need a license from the patent holder in addition to the license that you buy to use the ISO standard. So if the patent holder has chosen the FRAND licensing option, this ensures that you can access the technology as a user of the standard, but not necessarily for free. And for research organizations, this is where it becomes strategic. So standardization can turn your patented technology into part of global infrastructure, but it means you need to commit to shared access. So you need to align your research and IP strategy as early as possible to decide whether you want your patented technology to become a part of a standard and under what conditions you would allow that to happen. So to conclude, if there's one thing to take away is that standards operate with two levels of intellectual property. We have the copyright that protects the standard as a document, and that's why standards are licensed rather than distributed at no cost, because the revenue is sustaining the global ISO system that is developing, maintaining, updating the standards and keeping them independent with broad international participation. And then secondly, we have patents that protect the technology inside the standard. And the ISO patent policy is ensuring that this doesn't block implementation of the standard by requiring access to the patent under FRAND licensing terms. So in practice, using a standard involves two things: access to the standard itself, and in some cases, accesses to the patent technology within that. So again, for research organizations, there's a real opportunity. Standardization is not just about dissemination. It's a pathway to really scale your technology into global use if you align your IP strategy early and determine how you're willing to license that. And that's all from me. Thank you very much.
Thank you so much. Thank you so much, Belinda. So we heard a very important thing today, and we received one question if we can all discuss more about this. So I will just read the question. Since patent essentiality is not verified by ETSI or CEN-CENELEC or ISO or other standard development organization, this creates a complex situation for many patent officers in European research organizations. So, do you have any advice? What advice would you give for newcomers dealing with standard essential patents topics? So, what should they keep in mind? Do you have any advice?
So first, when you talk about the complexity for patent officer in European research organization, do you mean to as providers of patents in standardization, or to use maybe standards in
No, people who would like to participate in standard development but protect their patent, but they are starting. So they are aware that there are a lot of standard essential patents, but they want to start in it. There are a lot of patent officers who are working in academic institutions, in research organization and research support organization, who are a little bit afraid of a number of standard essential patents and complexity of whole that. So do you have advice for newcomers in this area?
Well,
where to start?
Yes, where to start? That's a very large question.
If you have one simple answer.
No, I don't know if it's a simple answer, but when we talk about complex situation, there are some technologies where you have a lot of pattern. It's the case in a video codec, for example. It's the case in a 3GPP standards, for example, but it's not the case for all standards. For some of them, the patent landscape is much more reduced. So I don't think that the first thing is to be too much afraid globally about patent and standards. For me, what I would find more complex if a research organization wants to go in standardization with a strategy in relation with patents is in some domain, it's this logic of developing a patent portfolio, which is not necessarily something that is let's say always natural in some research organization or some universities. That's that question of developing patent portfolio. It also requires to rely very often on specialized patent attorneys to draft the patent application. You have to synchronize it a lot with the course of standardization work to develop this this patent portfolio. And so I think that's what can make it complicated. And I know that in my previous life, we had a successful case where we managed to push a patent in standardization by collaborating and partnering with an industrial partner who also had the capacity to work with us and to take part of also the licensing part that goes with it afterward, because you then have to also be in capacity to scale up for the licensing part.
Thank you so much. So correct me. It is very important for our audience to have in mind that it's depend on domain. In different domain situation is very different, so they should not be afraid to start all process, and a collaboration is very important. So thank you so much. Judith, do you have any idea how to help us?
I think already quite a lot is said by Magali, so I don't have anything else to add, just to indeed to let yourself informed on how all works and assist by technical committees and experts on the standardization system. That I would also give as an advice to surround yourself with people who are an expert on that as well.
Thank you so much. Belinda, do you have any advice for us?
Not really. Just if you have questions, ask some colleagues in the technical committee. There are lots of other experts that have been there for a long time that would have good advice to offer. And if not, you can always ask the technical program manager at the ISO Central Secretariat as well. They're very familiar with how the patent policy works. So there's always advice. So my advice is just, if you're interested, ask.
Oh, can I just correct me if I'm wrong? You said start with standardization, join the technical committee, subcommittee or work group, and you will find out way through collaboration. And there are a lot of knowledgeable people in standardization, so you can find. I think that might be very good leitmotif of this presentation. Judith, Magali, and Belinda, thank you so much for joining us today. We learned so much from you, and I think that this recording will be a huge success because we heard a lot of things which are important for research organization in Europe and academic institution, especially for technology knowledge valorization officers. Thank you so much. I will continue with, if I can share just one information with all of you. It is related to our office. I'm so sorry. To our new service, which is related to mentoring. So IAM4RE has an open call for researchers and technology transfer officers and professionals aiming to maximize the value and impact of their intellectual assets and project results. Please apply and try to see what is in there for you. Thank you very, very much for your participation in this webinar, and please stay tuned. Our next deep dive webinar will be related to different aspects of market analysis for research and project results, and it will be on May 5th. Thank you so much for being today with us. See you soon, and have a nice day. And of course, Eastern holidays. Thank you so much. Bye. See you soon.
Thank you all very much.
Thank
Thank you.
Thank
Bye-bye.
you.
Thank you.
Bye. Bye.
Goodbye.
Thank you.